All right, it's 7 a.m. We shall begin. At this time, I would like to call this meeting to order. Good evening, everyone, and welcome to the Rent Stabilization Commission meeting tonight on Thursday, June 10th, 2021. Vice Chair, could you lead us in the Pledge of Allegiance, please?
Yes. I pledge of allegiance to the flag of the United States
of America,
to the republic which it stands, one nation, under God, indivisible,
with liberty and justice for all. Thank you. All right. Mrs. Secretary, can we have a roll call, please?
Commissioner Copeland, not present. Commissioner Ayers.
Here.
Commissioner Maggio. I see, I'm not sure if you were on mute or not.
Here I am. I'm sorry, I am here.
No problem. Commissioner Martz, let me admit him into the meeting now. All right, Commissioner Martz, we're going through roll call and you're up. Commissioner Martz.
I am here.
Commissioner Montemayor.
Here.
Vice Chair Kirby's.
here.
Chair Topshin.
Here. We have a quorum. Thank you. All right, Commissioner's approval of our agenda is next. Do we have a motion to approve the items as presented?
I'll
So
make a
moved.
motion to approve the agenda for this evening's meeting.
I'll second that motion.
Okay, we have a motion to approve the agenda as presented, and the second. Mrs. Secretary, can we have a roll call, please?
Commissioner Copeland.
Aye. Yes.
Commissioner Ayers.
Yes.
Commissioner Maggio.
Yes.
Commissioner Martz.
Yes.
Commissioner Montemayor.
Yes.
Vice Chair Kirby's.
Yes.
Chair Topshin.
Yes, agenda is approved. Thank you all. Next is approval of our minutes, and that would be the minutes. I hope everybody has a chance to review them. The minutes are from our last meeting on May 13, I believe, right? May 13, 2021 of the Rent Stabilization Commission meeting. Do we have a second? Do we have a motion to approve the minutes?
I'll make a motion to approve.
And I'll second that motion.
Okay, we have a motion to approve the minutes as presented, and second, Mr. Secretary, we need a roll call.
Commissioner Copeland.
Aye.
Commissioner Ayers.
Yes.
Commissioner Maggio.
Aye.
Commissioner Martz.
Yes.
Commissioner Montemayor.
Yes.
Vice Chair Kirby's.
Yes.
Chair Topshin.
Aye, motion carries. Thank you. Then next is public comments. Mr. Secretary, are there any public speakers at this time?
No speakers at this time.
All right, we don't have any speakers. Moving on to the manager's report. And acting Rent Stabilization and Housing Manager, Mr. Jonathan Holub is here. Good evening, sir.
Good evening, Chair, Vice Chair, Commissioners. Jonathan Holub. I am the acting manager for the Rent Stabilization and Housing Division, and this is the look ahead for the coming weeks. Tonight, we have an appeal, and we'll also be getting a presentation from staff on an item related to the adjustment of the security deposit interest formula. At the next meeting on the 24th, we have another appeal, and that is when staff will present for the Commission's approval of the annual general adjustment. On July 8th, there's another appeal. We'll also be doing the reorganization of the chair and vice chair at that time. And the commission will also be receiving a report from the ad hoc committee on valuation guidelines. For the meeting of July 22nd, another appeal. And there'll be a presentation from staff regarding the housing element update. And at that time, there might be some regulation amendments coming forward. I'd also just like to add, for the benefit of anyone watching, that the state California COVID-19 rent relief program still has funds available. That's the program in which a landlord, if they agree to participate, will receive 80% of the rent that has been in arrears during the emergency period. And the website to receive that information and to apply is housingiskey.com. If that doesn't work for you, you can go to housing.ca.gov. And I'm finding that now the applications are in a variety of languages and funding is still available. So I encourage anyone who has gone into arrears during the emergency period to look at that and to see if they qualify and encourage them to apply. That is the end of my report, and I'm available for any questions.
Thank you. Commissioners, are there any questions for the manager? Commissioner Maju?
Manager, do we have an update on recertification of affordable housing?
That is ongoing. It is the recertification period. Our primary staff member who's involved in that is working with property management companies that work with the tenants to get that information. And I encourage anyone who is in an inclusionary unit and is contacted to provide that information to do so.
They have to be contacted by the management company, or the tenant should to contact them. What would you suggest?
If the tenant hasn't heard anything, I'm sure they can certainly reach out, but they should be working together to supply that information.
All right, thank you very much.
Was this about the annual recertification for affordable units, or it's okay? It's not a new project, right? It's.
I don't think that, yeah, I understood the question to refer to existing inclusionary tenancies.
Okay, thank you. Commissioners, other questions? Anyone? All right, I don't have any questions to you, Mr. Manager. All right, so then moving on to the commission comments. Commissioners, this is our time. Commissioner Martz, please.
There we go. I just want to encourage everyone on the commission as well as the public to attend, if they can, the city's housing element presentation on Tuesday, June 15th at 6 p.m. The housing element, in brief, the city has to plan for 2021 to 2029 housing growth. With development and growth is always a hot and fun topic in this wonderful city of ours. And if you want to give your input, because sometimes people don't feel like their voices are heard, this is a great way to have your voices heard. They just did a survey of people, but you can still write in, make your voices heard. So there's lots of interesting things, and it covers a 8 or so year period. So I encourage everyone to do that. You can sign up for the Zoom on the West Hollywood website, weho.org/housing element. And again, Tuesday, June 15th, which is next week at 6 p.m. And that's my comment. Thank you.
Thank you, Commissioner. Other comments from other commissioners? Nothing at this time. All right. Then we're going to move on to the next agenda item, which is the appeal section of our tonight's agenda. And we have one appeal before us tonight, and that is a rent reduction application D-4566 that pertains to the property address 8110 West Norton Avenue, unit number 8. And this appeal is filed by the tenant. Mr. Secretary, before I move on, can you confirm, please, if the parties are here?
They are. I'll admit them now. We have the tenant and 2 representatives for the property owner.
For the property owner, and there's no connection issues. I hope so. And this deal. Okay. So before we begin, I want to bring up some instructions. First, I would like to take a moment and explain the process of the appeal tonight. First, the commission will hear the staff report presented by the department's legal counsel, Mr. Natalizio. After that, I will open the public testimony portion of the appeal. And first, I will invite the appellant, in this case, the tenant, to present the case. The tenant will have a total of 5 minutes to present the case. You have the option of dividing your 5 minutes into 2 segments. You may use part of your 5 minutes to present your case and part of 5 minutes for rebuttal portion of your testimony tonight. The respondent, in this case, is the landlord or the landlord's representative, will speak second. The respondent will have 5 minutes in total as one segment to present the owner's position, the landlord's position on the appeal matter. When it is time for you to speak, you will state your name for the city of state your name and the city of residence for the record. As I said, the appellant will state how 5 minutes will be divided, if at all, and then you will proceed with your comments. Well, since your speaking time is limited to 5 minutes, it is particularly important to keep the following things in mind. Keep your comments on topic. The only information you want to share is information about your appeal topic. And new evidence cannot be presented or heard by the commission. No new issues may be considered, nor may new evidence be admitted unless it is shown why the evidence could not, with due diligence, have been presented at the hearing. You may present such new evidence at the appeal meeting if the commission approves your request to do so. Well, after that, the commission will have a time to ask questions to the legal counsel, and then public hearing will be closed and the commission deliberation will begin. And with that said, legal counsel, we're ready for your report.
Thank you. Good evening, Chair, Vice Chair, and Commissioners. My name is John Natalizio. I'm the legal counsel to the Rent Stabilization Commission for the City of West Hollywood. This appeal was filed by the tenant, Roberto Nabaza, who resides at 8110 West Norton Avenue, Unit 8. Tenant filed an application seeking a rent reduction for an overly noisy air conditioning unit, which is built into the wall in his living room. Tenant claims that the air conditioning unit becomes so noisy that at peak power, it prevents him from hearing the television. The air conditioning unit is owned by the landlord. The record shows that the landlord had the air conditioning unit inspected by its handyman, as well as a third-party contractor, Miguel Appliances Incorporated. Both inspections resulted in a determination that the air conditioning unit was in good working order and was not overly noisy. At the hearing, tenant also played audio of the air conditioning unit to the hearing examiner. And based upon the evidence and testimony submitted at the hearing examiner denied tenant's application. Tenant appeals the decision, claiming that it is clearly in error, is not reasonably supported by the findings made or the evidence in the record, constitutes an abuse of discretion, and is contrary to the specific provisions of law. Tenant specifically challenges that the inspections were faulty due to the bias of the inspectors and that there's no reliable evidence in the record supporting the hearing examiner's decision. Staff has reviewed the appeal record and recommends affirming the hearing examiner's decision. Staff believes that the hearing examiner's decision is supported by substantial evidence and that the hearing examiner correctly applied the law to the case. The evidence for this matter is minimal. In total, the hearing examiner had the testimony of the landlord's property manager and handyman, the testimony of the tenant, an invoice from the third-party vendor, Miguel Appliances, and the audio of the air conditioning unit played during the hearing. Substantial evidence does not require large quantities of evidence. Rather, it requires evidence that reasonably supports the hearing examiner's decision, is credible, and of solid value. That is, could a reasonable fact finder have come to the same conclusion based on the facts in the record? If that evidence is found, then the decision must be upheld, even if there's contrary evidence. Staff believes that the record contains substantial evidence to support the hearing examiner's decision. The record shows that there were only 2 inspections completed of the air conditioning unit, one by the handyman and one by a third-party contractor. Both inspections resulted in the same conclusion, that the air conditioner was in working condition and not overly noisy. The record also reflects that the noise of the air conditioning unit was played before the hearing examiner. The parties also testified at the hearing. Other than questioning the integrity of the inspectors and claiming their bias resulted in faulty inspection, the tenant produced no evidence that would have contradicted the inspector's conclusions. Therefore, based upon the above, staff recommends adopting Resolution RSC 21-593. You as the commission have the power to affirm, reverse, modify, or remand the appeal determination of the hearing examiner as you deem fit. The commission reviews the hearing examiner's decision under the substantial evidence standard, which requires the commission to make sure there's substantial evidence that reasonably supports the hearing examiner's decision, is credible, and of solid value. If that evidence is found, then the decision must be upheld, even if there is also evidence that could support a different outcome. The commission does not substitute its judgment for that of the hearing examiner or reweigh the evidence. As it relates to questions of law, the commission applies an independent or de novo standard of review to the hearing examiner's conclusions of law. Thank you.
Thank you, Mr. Natalizio. Commissioners, any questions at this time for the legal counsel? I might have something later, but if no questions, I will open the oral argument portion of the appeal, and I will invite the appellant, who is the tenant. Sir, please, as I said, you will have 5 minutes. Please indicate if you'd like to divide your time and how many minutes. Just hold on a second. Commissioner Maggio, you're raising your hand?
Yes, are not all the commissioners to be on screen during the public hearing?
I didn't catch it.
I believe all the commissioners should be showing their faces on screen during.
Yeah, I think.
And there's only 2 of us showing that.
Oh, really? I think I see all of us.
I see everyone.
I see all 7 commissioners. And thank you, Commissioner Maggio, for reminding, and I, for bringing up. I want to remind the commissioners, please, during the appeal, make sure that you are visible, and if you will need a break, a few minutes, just let me know. But please be on the screen all the time. Thank you, Commissioner Maggio. Yes, sir. I just want to continue that. Please indicate if you'd like to divide your 5 minutes, and indicate how you would like to divide between the presentation and the rebuttal portion.
I'm not going to say much. I'm going to save the 5 minutes. It's probably going to be less than 5 minutes.
You want to take the 5 minutes now entirely? And
Yeah.
Okay.
I don't need to do anything, but I think that my appeal was very.
No, don't talk about the appeal right now. Just so as you indicated, you want to take the entire 5 minutes now,
right.
without the minutes for the rebuttal.
That's right.
Fine.
I'm
Fair
not
enough.
going to rebuttal.
Okay, so then just state your name for the record and you can begin.
Roberto Rabasa. And what I have to say is that I believe the appeal that I filed speaks for itself. I'm sorry that you have to read all that. It's very extensive and to the point. And the only thing I want to stress is the fact that Mr. Snyder based mostly his decision on the Angel Appliances invoice. Actually, he said that he has no interest in siding with either party. That's what I have a problem with, because Angel Appliances, who I believe is also Angel the Plumber, does extensive work for the landlord. The landlord boasts to have over 30 buildings. So my question is, would somebody that has, and it says so in my appeal, that has so much business coming from this landlord is going to risk business by telling the truth or worrying about one air conditioner, I think that alone shows that the discretion of the hearing examiner went too far. And in the case of noise, which is not only noise, I also said that it's inefficient. It doesn't work as it should. Noise, it's something that actually shows the compressor is about to fail. It's going to fail in a minute. It's a very old equipment. The only way to show it's subjective, the question of noise, and the only way to show it is by showing a video. And it would have been better in person, or if I had been able to upload the video. I did not play a recording. I just was asked to go next to the device, turn it on for 2 minutes, and it was heard through the phone. And as I said in my appeal, I don't know what they heard on the other side. So I think that actually, and I don't want to make this too long, once you realize that this decision is left with no legal support, the whole determination falls apart. And no matter how you look at it, and I was not allowed to present the only form of evidence in case of noise, a video, noise that shows the compressor is failing, as I said, etc., etc. I had a working air conditioning ever since I moved into this building 27 years ago. And because of that, and I believe the landlord is in breach of contract for not maintaining it, I request that this commission finds in my favor, reverses the hearing examiner's decision, and approve my rent decrease application. That's all I have to say. The rest is written in my appeal.
Mr. Secretary, how much time the tenant has left?
1 minute and 52 seconds.
1 minute and 52 seconds. Sir,
Remaining.
you will be, sorry?
Sorry, remaining.
Remaining. So you have remaining 1 minute, 52 seconds. And if you wish to use it as your rebuttal after the owner speaks, you can do that.
All right, appreciate it.
All right,
But
but let me ask the commissioners if you have questions for the appellant at this time. Vice Chair, please.
Yes, thank you. I just had a question for you about in the hearing with the hearing examiner, as the evidence was being laid out for the landlord, and he mentioned about the bringing in the repair person or the repair person to do the survey or review. You had an opportunity at that time to make the argument that you just did about the biasness of the appliance person, that he worked for several companies. Did you make that argument at that time?
I don't remember if I did. A lot of things were said. I didn't think I actually had to clarify that to a hearing examiner.
Okay.
And okay.
Fine. Yeah.
No,
Thank you. I think you answered.
Commissioner Morris, followed by Commissioner Ayers.
Yes, my only question is, in the notes, it says that you did not disagree to having a telephonic hearing only. Do you remember agreeing to that, or can you explain the process? Because I know that a lot of your case seems to stem from video, not audio. Thank you.
Well, I don't have a problem with a telephone conference. In fact, I'm an interpreter. I work for the courts, and we do it telephonically. Okay. So, but as they do in court, I don't have to show any evidence, but the attorneys, they can upload or send a link to whatever evidence they need to show the judge at that time so he can review it, even though we're doing it over the phone. I didn't have that opportunity. When I said I was agreeing to that, was not because I wanted it, I thought it was good, was because I had to stop working that morning. I had requested the hearing to be held in the afternoon, and I've lost my fees. So if I had to ask for another date, the same thing was going to happen. If I kept spending money, I would buy the air conditioner myself.
Got it. Understood. That answers my question. Thank you.
Thank you.
Okay, great.
Thank you.
Thanks.
Commissioner Ayers?
Yes, Mr. Nabasa, good evening.
Good evening.
In your opinion, do you think the noise that you find objectionable from the air conditioner is coming from the air conditioner itself, like a mechanical malfunction? Or do you think it might be from the way it's installed in the wall, that it's rattling, like some kind of exterior sound?
No, it's the mechanical noise the air conditioning is making because it's about to fail. It's typical. It's a typical noise of compressors when they get worn out. And it's not that it makes noise at the beginning and then it disappears. It makes noise all the way, all the time it's running. And when it gets wet, this apartment gets very hot because I have the roof on top and windows all around. So it's a cauldron. It's like an oven. So I have 3 more air conditioners that I had to install in other rooms that I'm responsible for, and the 4 have to be run during a hot day to keep this cool. Without that one, it doesn't work. I cannot even use the living room if I don't have the living room. During the hot hours of the day, between the noise and the fact that it's insufficient, and I cannot change it. I cannot replace it. It corresponds. It's a special. It's in the wall. It has to do with the landlord. It's not my air conditioning.
Is the what was the question I had? Is the noise does it get worse when it's warmer, or is it a consistent noise level?
It gets worse when it gets warmer.
Okay.
But it's loud from the beginning. But when it gets warmer, and the device is under stress, it starts getting very, very loud.
Thank you.
You're welcome.
Thank you. Other commissioners? All right, seeing none. So, sir, we're gonna call you back to use the remaining 1 minute,
All right.
52 seconds after the representative for the owner speaks. All right, thank you very much for your
I
testimony.
mute myself.
Thank you. And now I'd like to invite the respondent, the representative for the owner.
Hello.
Okay, hello. As I said, hi, good evening. As I said, you will have 5 minutes to present your position in this complaint matter, in this appeal matter, and then you have to stick to the issues that were discussed at the hearing. Now, can you please state your name and the city of residence before you begin?
Sure. My name is Marla Miller. I live in West Hollywood.
Okay, thank you, Ms. Miller. You may begin.
Okay, first I wanted to say that Mr. Nabaza was allowed to submit a video, because in the hearing instructions, item 2, it says, how might I prepare for the hearing? It says that if the photos or documentation don't establish what you want, you can go further. And Mr. Snyder gave us 7 to 10 days extra to submit evidence because my boss's mother had passed away, and so the office was closed and we didn't get the hearing notice until just a couple days before the hearing. So Mr. Snyder gave us extra time so Celeste could give him the invoice that we had submitted, which was not from Angel. Angel's Appliances is a separate vendor. We called Miguel's Appliances, but now I guess he wouldn't trust Angel either. I understand. But the other thing is that even if he supplied a video, you can't hear a video. We all heard the AC, which sounded normal the day that he played it. Guillermo told me that it sounded exactly like Guillermo's. We installed the brand new AC for Mr. Nabaza in 2013. Mine is that age too. When the compressor starts, when it's really hot, it makes noise, but then it settles. Guillermo couldn't hear anything different. He thought it was normal. Miguel thought it was normal, and then he played it on the phone, and we couldn't hear anything. So it's not as if it would keep him from watching TV. So yeah, and I don't think Miguel's appliance or Angel's appliances would say that it doesn't make sense that they wouldn't want to replace an appliance or repair an appliance. That's how they get their money. So anyways, that doesn't make sense. And the only other thing I wanted to bring up is on the paperwork. I noticed on the original hearing notice dated September 18th, it says that he moved in on 8/1/19, but he's lived there. He was living there when we got the building in 1998. He took us to a rent decrease hearing that year, and he took the previous owner the year before. So that's all I'm going to say.
Thank you, Ms. Miller. Okay, don't leave. Let me ask if my fellow commissioners have any questions for you. Commissioners.
Okay.
Commissioner Maggio, please.
Well, all that information you just gave us now has nothing to do with this case. You understand that. Whatever he did before has nothing to do with this air conditioning. So,
Oh, you mean the last two
So that
sentences?
should
Yeah,
not
but everything
have
else
been
is,
said.
okay, I'm sorry.
You're trying to support your argument, and it's not fair. All right, that's what I want to say.
Thank
Okay,
you, Commissioner. Other commissioners with questions? Okay, no questions, Ms. Miller. All right, let me invite Mr. Nabaza back. And sir, you will have your remaining 1 minute 52 seconds for the rebuttal. And if you have anything to add to what you said, or if you want to respond to Ms. Miller's statements, you can do it now.
Yes, first thing is, I was never offered to, in fact, I was told not to upload videos or photos, even after, during those 10 days. It was part of the rules, okay? So that what she said is wrong. The other thing is, actually, I don't have much. All she did was repeat the same thing.
Okay.
There's nothing to argue about. I mean,
All right.
the appeal speaks for itself and what I said also. Thank you.
Okay, so that concludes your statement?
Yeah.
All right. Thank you, sir. But let me ask my fellow commissioners, do you have any questions? Yes, Commissioner Montemayor.
Mr. Nabaza, you said that you were told not to submit any evidence. Can you clarify that comment, please?
Not evidence, videos or photos. We could not upload them in advance. Then the system was not working that day. And I was told that I couldn't upload during those 10 days any new, I mean, I could upload new evidence, but no videos and photos. And there were two things the guy from Angel Appliances said was that it was the air conditioning was blocked in the back in the balcony, which is not true. And I wanted to show a photo that there's more than enough space. And the other one was about the noise. And the only thing I could do, short of bringing you all here to hear it, is upload a video, a recording of how it works. And I was not allowed to do that before. I was not allowed to do it during the meeting. And I was not
understand.
Afterwards.
Right,
I was left with nothing.
Okay. Did I answer your question, Commissioner?
I think my clarification is who told you, or maybe I don't fully understand.
Yeah, let's clarify. Mr. Nabaza, did you understand the question the Commissioner asked? Who told you not to present, not to bring any photos? I believe that's what you said.
Instruction. Oh, sorry. It was in the instructions before the meeting that we couldn't upload anything in advance. During
Who
the
said
meeting,
that? I can't hear you. Can you speak up? And
in the instructions that I received, the email.
Instructions you received.
Instructions. It said that we couldn't do it beforehand.
All right.
In my experience on other hearings that I had in person with the city, we would present them right there.
So let me ask a clarification question. What the instruction was in writing, and in writing it said, do not bring any pictures, any photos?
No, in writing it said not to upload in advance, before the date of the meeting, any evident videos or photos. Now, afterwards, during the meeting, I was not allowed by the hearing examiner to do it. And when he says I played a recording, I didn't play any recording. I was asked, and you can read actually, I'm sure there's a recording of the meeting.
Okay.
I was asked to go with my phone to the device, turn it on for 1 minute, and I
All
don't
right.
know what they heard on the other side.
You answered the question, Mr. Navazo. Thank you so
All
much.
right.
Thank you.
Thanks.
Did I see anybody raising hand? Okay, Commissioner Ayers, please.
Yes, Ms. Miller, I have a question for you. I'm wondering if your handyman or the technician was able to take the temperature of the room. Do you know how warm the room was at the time that in the apartment when the repairman and the technician visited?
In the original hearing, all we knew was the temperature of the day that he went. We looked that up, and but no, I don't think he measured anything. You'd have to ask Guillermo that. But again, it's not Angel. Angel is a plumber. Angel doesn't touch air conditionings. He's one of our vendors that's a plumber. So Angel had nothing to do with this. It was Miguel's Appliances that we contacted. So again, you can ask Guillermo if he measured, but I don't think we did, but both said it was blowing normal, cool, and it sounded normal. And again, if you look at the hearing, it says that you can, if the evidence, photos and documentation, then you can request to upload the video.
Okay, thank you. Guillermo, if you can unmute yourself and basically answer the same question, were you able to confirm the temperature of the room or the temperature of the air blowing out of the air conditioner when you visited? Guillermo, you'll have to unmute yourself. Is it?
Yes.
Darcy.
Can you hear me there?
Yes, thank you.
Okay. Hi, my name is Guillermo Villarreal. I'm the handyman there. And yes, I was there on just a regular day. It was not that hot, but I didn't have any instrument to measure the cool. The AC was turned off at the time I got there. So when we turned it on, I mean, it was blowing, and I was there for a few minutes. It was just making it's like regular, like I had the same AC, you know, when we turn it on, it's quiet. When the compressor turns on, you know, that's when it starts sending the cooling thing. But he wasn't happy for that, you know, if he wanted a new AC. So that's when I contacted my boss, and I told him, you know what, I mean, maybe he wants a different opinion than a handyman. So then that's when my boss contacted Miguel's Appliances. So he went to check, and he came up with the same, you know, with the same results. He checked the AC. I mean, the noise was normal, as most of them, you know. So, yeah.
Thank you.
Thank you.
You're welcome.
All right. Others, I think, Vice Chair, did you raise your hand or? Okay. All right. If we don't have any more questions for the parties, I will close the oral argument part of the appeal, and we may begin our discussion. Okay, so oral argument is closed, and commissioners, we may begin our discussion. If we have any questions or clarification from staff, we can do it now before we begin the deliberation. Commissioners, anybody, Vice Chair?
Can we just ask staff if they're familiar with what may be in writing about evidence and what can be uploaded in before and during and after the hearing?
At least to my knowledge, for this case, I just put in what the notice hearing was. If there were emails that were saying something differently, at least I haven't seen those, and those weren't presented to the hearing examiner, and the hearing examiner didn't consider them. So they do exist. At least they're not a part of the record. Not saying they don't exist, but they weren't presented if they do exist. And I'm not aware if they do exist, those kind of emails.
I think my question has to do with do our forms say that? I'm not actually talking about the actual evidence. I'm just wondering if you're familiar with any of our forms that say you can't upload information, or does the hearing examiner send out emails stating things like that?
No, I'm not familiar with any form that would prevent a party from saying that, and I don't think your hearing examiner would be permitted to contact any of the parties ahead of time. I think that's a standard.
Vice Chair
maybe-
Kerpes, do you mind
maybe
if
we
I
can-
step in? I have a little
Sure.
bit of an explanation on that. So
Yes,
if you
Commissioner.
look to, and this goes into my comments, if you look at page 29 on our packet, it's the notice of rent adjustment hearing, date November 30, 2020, goes to both Crescent Management and Mr. Nabaza. I see this both ways. It says in yellow, any evidence you wish to have considered must be submitted electronically 3 business days prior to the hearing to the email address. And then it says evidence submission, you may submit up to 5 photos only per issue, blah, 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 blah. So I can see how someone who, or anyone, would be a little bit confused if you want to submit a video that pretty clearly tells you photos only. But if you go to page 30, which is more dense, frequently asked questions type page, how might I prepare? It does say in this number 2, you can submit video tapes and audio tapes only if that's the only way you can demonstrate the fact you're trying to establish, and that the evidence could not be established by using still photos or other documentation. So on 29, it says just photos. On 30, it says just photos, but it's an exception. However, I can see how someone could be confused. You know, as an attorney, I can wade through this pretty easily. But I can see how someone might be confused if they're not used to thick documents like that. So, Chair, I don't know if you want me to go into my final comments on my position or let others speak.
Yeah, well, I have actually, hold on, Commissioner Murphy, because I have another question, and I want to ask if other commissioners have questions. Commissioner Vice Chair Corpus, that completed your question?
Yes.
Commissioners, do you have any other questions?
No.
No? I wanted to ask legal counsel, Ms. Natalizio, thank you for coming back. So let me understand this. There were 2 inspections, right? One inspection or observation was by the handyman, and the other inspection was by the by Miguel Appliance, which is, I assume, a professional company agency that deals with this type of issues. But this was hired. This agency was paid. The services were paid for by the landlord. Correct. So the tenant didn't participate in the selection of this company. Basically, as far as I understand, the owner, at least I didn't see it from the examiner's analysis. So the owner decided to contact this agency to hire their services and to have them to come and do the inspection. So in my opinion, this is biased. In my opinion, this is not an independent inspection. That's how I see it. Maybe legal minds can explain differently. But when I looked in the, and this is kind of maybe a comment or a question, and you just explain if I'm right or I'm wrong. So in my mind, if the tenant participated kind of in the selection of this agency for the inspection, we could have said it's independent because the tenant agreed to invite specifically Miguel Appliance. Let's say, hypothetically speaking, the owner calls and say, hey, tenant, I have this company, a great organization or a great agency. Would you be okay if I call them and I get them? Ideally, it would have been in writing. If not, so even if it's verbal, so I'd say yes. And the tenant says, yes, sure, send them over. Then I would say it was independent because the tenant participated in a selection and okayed this inspection. Otherwise, I have a hard time to consider them as independent. In my opinion, the word independent would have been, again, if both parties agreed to select this agency, or independent would have been the city's inspection. And I wish there was a city's inspection on this matter. So what thought you would have on this?
So to answer, I think the initial question, my understanding is your understanding, and that this was a contractor that was hired by the landlord, and I guess presumably paid by the landlord. I don't know if there's evidence in the record if they were actually paid. I think that there's an invoice. I think it says like $0, but there's, at least to my knowledge, there's nothing in the record that said the tenant approved Miguel Appliances. Really, all that's in the record is that the tenant objected to the handyman, and that he wanted it done by a different person or a different entity, and then that's what the landlord did. To your issue of bias and whether it's biased or not, I guess that's a commission decision. I guess it doesn't really matter what I think in terms of if there is or isn't bias. I think that the only legal kind of issue that might want to be considered with what you're proposing is essentially saying that a tenant has the ability to impose on landlord some sort of condition in which, if they don't agree to landlords, contractors, then they'll never, agree that the work's sufficient. So that's just something to consider. But unfortunately, I can't tell the commission if it's biased or not. That's up to you guys. And if you guys, as a commission, think that there isn't substantial evidence, you can discuss those findings and make that. But I can't tell you if there was bias or not.
Okay,
Staff's
thank
opinion
you.
is that there is substantial evidence. And that, I guess that's the best I can do to answer your bias question.
I appreciate that. Thank you. Other questions? If none, we can begin our discussion, and I will have Commissioner Martz maybe to start.
Sure, happy to. So I think the first thing that we always start there is what can we do and what can't we? And we don't sit in the place of the fact finder. And if we find that there's reasonableness of the hearing examiner's decision, it's credible and of solid value, and if we decide whether a reasonable fact finder could have come to the same conclusion based on the facts of the record, even if there's contrary evidence, that we must uphold that decision. I think that's the case here. Whether we love the contractor or we don't, I think is irrelevant to the question at hand. There's substantial evidence that this contractor went out, another employee went out and found that it was working, and we have nothing to say whether this contractor was biased or not. So even though we might think they are, I don't think we have anything that shows they are or are not. So we can't decide one way or the other. So I would uphold the hearing examiner's decision. However, I do have some concerns about due process. I do think our forms can be a little bit confusing, not in general, but given the fact here that this was a telephonic only hearing because of some tech issues. The tenant said that there were other tech issues with uploading, and that in this case, the only way he could make his case, I think, is with video. I don't think holding a phone up and putting a video up to it is enough to be able to present your case in a fair manner. I would be in favor of waiving the 6-month refiling hold period. So I would uphold the hearing examiner's decision, but waive the 6-month waiting period to refile if the tenant felt that was necessary. And that's my thoughts. Thanks.
Thank you, Commissioner Martz. Commissioner Copeland?
I concur with a lot of what Commissioner March just stated. Because there were some issues with technical issues and so forth, I would have liked to have seen a contradictory inspection report maybe provided by the tenant, or if he could have gotten an independent one, you know, that there was some contradiction. That would convince me more of bias as far as evidence. But because of all the other issues, I certainly would not have a problem with waiving that 6-month period if we could, so that, you know, if he wanted to, he could certainly get independent information and present the evidence he felt he was not able to present maybe in another hearing. But I would like to hear what my other commissioners have to say.
Thank you. Commissioner Ayers?
Yeah, my takeaway is very similar. I do get a sense that adequate evidence was presented, adequate for the purposes of the hearing examiner to make a decision. And so I would be inclined to uphold that decision. I am also okay with waiving the 6-month refile. If the air conditioning unit is, as Mr. Nabaza believes, close to breaking altogether, then, you know, perhaps he would be able to come back with additional evidence of the need. So, yeah. Thank you.
Thank you, Commissioner. Commissioner Maggio next.
Well, this is an old air conditioner. It's 8 years old. It probably does need to be replaced. I suppose if it wasn't in the wall, the owner then probably would replace it itself. That, of course, is an issue. But I just don't see enough evidence here for me to say that there has to be a replacement. I do agree on the waiver. I think that will be helpful if the tenant feels that he could bring someone in who he thinks is independent. But other than that, I will have to support the hearing examiner's decision.
Thank you. Commissioner Montemayor?
I agree with all the comments that my colleagues have mentioned. I unfortunately just don't see enough information here to disagree with the hearing examiner's report and decision. I would agree with Commissioner Martz's recommendation of waiving this 6-month waiting period. If for whatever reason circumstances were to change for Mr. Nabaza, he could come back and present his argument once again, but at this time there's no evidence supporting denying the hearing examiner's decision. So thank you.
Thank you, Commissioner. Vice Chair, please.
Yes, thank you. I think that this was a perfect example of a case where the hearing examiner could have utilized the city's inspection staff to go out and inspect and make an unbiased decision. But and we've seen this hearing examiner do it in the past. So they didn't do it in this situation, but also at the same time, the tenant had an opportunity to argue the biasness in front of the hearing examiner, which I can't really tell from the record whether that argument was fully made or not, but clearly it was at least thought of by the hearing examiner, because the hearing examiner specifically mentioned his take on bias in the report. So I would agree with Commissioner Martz's recommendation, and I would also be open or be okay with waiving the 6 months. Although I do kind of believe that this conversation could have already, this argument could have already been made at the hearing. But I'm open to, or I'm willing to support Commissioner Martz's recommendation.
Thank you, Vice Chair. Yeah, I would agree or concur with what Vice Chair has said, particularly regarding the requesting an inspection by the department's code enforcement. for this type of cases. And this was the example of when the code enforcement inspectors should go out and conduct an independent, truly independent inspection. Because as I mentioned before, I had a hard time of understanding how the inspection by the landlord's contractor can be considered independent. However, the legal counsel gave a good explanation that the tenant cannot dictate or participate in the selection of the a contractor. Landlords should have the freedom of selecting who is the contractor should be to conduct repairs, etc. So I agree with that. So although I was leaning towards remanding this case back to the investigator, back to the hearing examiner to request an inspection. However, since Commissioner Marks recommended a waiver of that 6-month waiting period, so I have no problem with supporting staff's recommendation in this matter and to affirm the decision of the hearing examiner on this application. So with that, anyone would like to make a motion? Commissioner Maggio, since Commissioner Marks, okay, Commissioner Maggio, yes, sir.
We have a lot of M's, I guess, right?
Yeah, no, I saw your hand before I saw Commissioner Marks.
I would like to make a motion to adopt resolution of the Rent Stabilization Commission 21-593, which is a resolution of the Rent Stabilization Commission of the City of West Hollywood, affirming the hearing examiner's decision as to rent decrease for application number D-4566.
And we need to, I believe we need to add that.
Yes, and I would add that we allow a 6-month waiver to be considered or to be determined.
To be removed, right? That 6-month waiting period, right? Okay, do we have the motion and anyone?
Second that.
Commissioner Marks seconded. Any further discussion on motion? I've seen none. And Mr. Secretary, we are ready for the roll call.
Commissioner Copeland,
Aye.
Commissioner Ayers,
Aye.
Commissioner Maggio,
Aye.
Commissioner Marks,
Aye.
Commissioner Montemayor,
Aye.
Vice Chair Kirby's,
Aye.
Chair Topshin.
Aye. Motion carries. Thank you, commissioners. Thank you to both the tenant and the representative for the owner. If any of the parties have questions regarding tonight's meeting, please feel free to contact our staff during normal business hours. So this appeal application is now closed.
Mr. Chair, maybe we have a 3-minute recess.
Sure, we can have a 3-minute recess.
Chair, I think you're on mute.
I just noticed that. I'm sorry. Okay, so thank you, Commissioner Harris. So we're back to the meeting, and the next item on the agenda is a new business, under which we have one topic to discuss tonight, and it's the new item that staff will present. That's the recommendation on amending the annual security deposit interest rate formula for rent stabilized properties in West Hollywood. So we will receive staff report and we'll consider amending the security deposit interest rate formula in West Hollywood rent regulations. I hope that everyone had a chance to review the recommendations submitted by the department. And with that said, I will have yes, Ms. Wright, you're going to make a presentation on this item? Okay, perfect. So just this is your time. Go ahead.
Thank you. Good evening, Chair, Vice Chair, Commissioners. Good to see you all again. So as Chair Topchin mentioned, I do have a presentation for you that is an overview of the staff report that you received, but I'm hoping we can use it as a guide to our discussion tonight, your discussion tonight. Can everybody see the PDF presentation? Yes, okay.
Yes.
So I want to start out with a bit of a background on the security deposit interest rate formula. We'll then be reviewing some of the local city regulations, looking into the research that we put together based on online savings accounts and certificate of deposit accounts, and then finishing out with the recommendations. So at the December 10th Rent Stabilization Commission meeting, the Commission directed staff to explore the feasibility of adjusting our security deposit interest rate formula, considering that now we have more online and other options for banking available to West Hollywood landlords, residents, outside of just those that have brick and mortar locations within our city limits. Currently, the rent stabilization regulations require that the interest rate that landlords pay to tenants for holding security deposits, that they be calculated by averaging the rates for regular savings passbook accounts at 5 West Hollywood banks. And again, that's for banks that have brick and mortar locations in the city of West Hollywood, and rounding that average to the nearest 1/4%. And for nearly 10 years now, since 2012, that security deposit interest rate has resulted in 0% interest paid to tenants for their security deposits. And so for this last year, for the 2020 rate, these were the 5 banks that we used in order to make the calculation. The average turned out to be 0.024%, which rounded to the nearest 1/4% was 0% again. And so as far as the history of that interest rate formula, initially the rent regulations set a specific interest rate that would be paid on all the monies landlords held as a security deposit. And then in 1994, because of fluctuating interest rates, those regulations were amended and they required landlords to pay tenants a security deposit interest at a rate based on those rates paid by local banks on 6-month CDs or certificate of deposits of $1,000. Then in 2001, that interest payment requirement was temporarily suspended due to litigation that occurred in the city of Santa Monica. There was a class action lawsuit, and the landlords in Santa Monica alleged that the landlords were not able to obtain the 3% interest on security deposits that were required, and that this regulation affected a taking for which the Rent Control Board should pay damages. So again, as a result of that litigation, the city of West Hollywood temporarily suspended the interest rate payment requirement. And then in 2002, the regulations were again amended to set the formula for calculating the interest rate to what it is today, which is to have it each year based on the average of rates for regular passbook savings accounts. at 5 of the West Hollywood banks. And again, that's what we that's the formula we continue to use to this day. And so we looked at it into some local cities, some Northern California cities, to see what they were doing. And as mentioned before, the city of Santa Monica, due to litigation, now does not require owners to pay any interest to their tenants on their security deposits. But they do state that all security deposits are required to be placed in interest-bearing accounts at an institution that is FDIC insured until they're returned to the tenants or entitled to be used by the landlords. LA does require, the city of Los Angeles does require landlords to pay an interest rate, and they calculate this in one of two ways. One is using a simple interest rate that's established by their rent adjustment commission based on the average of the interest rates on savings accounts paid on September 1 of the previous year by at least 5 FDIC insured banks with branches in Los Angeles. And then that interest rate is established by the Rent Adjustment Commission, and it is in effect from January 1 through December 31 of the subsequent year, so by calendar year. Or they're supposed to pay the tenant the actual amount earned on the security deposits. And if this method is used, the landlord has to provide the tenant with a copy of their bank statement that indicates that interest that was earned on their deposit for the year. So as far as that first option goes, the interest rate that was set by the Rent Adjustment Commission for this year, 2021, is 0.06%. In the city of San Francisco, their administrative code requires landlords to pay interest annually on their security deposits that are held for residential properties. And this is a bit different from ours in that it applies to all residential units in San Francisco, including those that are exempt from the rent ordinance or the rent stabilization ordinance. The only exception is if the rent for that unit is assisted or subsidized by a government agency, and in that case, the interest payment requirement would not apply. And then starting in March, or on March 1st of 2015, their rent board calculated the interest rate according to the annual average of the 90-day AA financial commercial paper interest rate, that one's a mouthful, rounded to the nearest tenth for the immediately preceding calendar year as published by the Federal Reserve. So for this last year, the rate of interest owed on deposits in the city of San Francisco for the period of March 1, 2021 through February 28th of next year is 0.6%. And then lastly, in Berkeley, their rent stabilization ordinance does require landlords to pay tenants annual interest on their security deposits, those payments of which are due each December, which can either be issued as cash payment or as rent rebates. And what they use is what they call the Berkeley bank rate, which is the rate equal to the 12-month average of the average rates of interest, or APY, paid on the first business day of each month for 6-month certificate of deposits with 5,000 minimum deposits by insured commercial banks doing business in the city of Berkeley. So they also have a geographical requirement. And Berkeley property owners may use that Berkeley bank rate regardless of whether the security deposit is held in a bank located in Berkeley. And the interest rate that they required in December 2020 for security deposits held from November 1st, 2019 through October 31st, 2020 is 0.2%. So that sums up what other cities have been doing in relation to their security deposit interest rates. Now jumping into a review of some of the online bank interest rates that we've seen. Right at the beginning of the presentation, we saw what the brick and mortar banks were offering. Now is a review of what some of the online banks are providing. So here we see that there's Capital One, Barclays, American Express, Discover, And the average interest rate for these 5 is 0.442%, which rounded to the nearest 1/4 would be 0.25%, so 1/4%. And then looking at some of those online security of deposit accounts or CD accounts, these had a much more variable amount in that depending on the amount of time that the account is held for, there's a different interest rate in many of these cases. And these first 3 for Capital One, Barclays, and American Express, they don't have any minimum requirements or monthly fees. And then these last 2, Discover and Axos, do have minimum deposit amounts. And then each of these have varying penalties for pulling out early. I know one of the discussion points was about keeping the money fluid. So something to keep in mind is that for the online security or CD accounts, that there are penalties in each of these cases for early withdrawal of the money. Looking at the interest rates here, I chose to just focus on the 12 months since there's quite a few different terms available here. So the average, at least for the 12-month online CD accounts, is 0.27%, which rounded to the nearest 1/4%, also results in the 0.25% or 1/4%. So the recommendations that are brought before you tonight are 1, to remove the requirement for landlords to pay that security deposit interest rate to the tenants, like the city of Santa Monica did, or to amend the current formula to include online savings accounts. That would include both savings and the certificate of deposit accounts. The new formula would calculate the interest rate on security deposits for each year by averaging the rates for 5 FDIC insured online savings accounts and rounding to the nearest 1/10%. And lastly, amend the current formula to calculate the interest rate on security deposits for each year by averaging the rates for regular passbook savings accounts at 5 West Hollywood banks and rounding to the nearest 1/10%. So if you want to stick with the brick and mortar accounts, to keep those, but change the rounding to the nearest 1/10%. And that concludes my presentation. Thank you.
Thank you. Thank you very much, Desmond. One question. So Santa Monica, as you explained, Santa Monica does not require for landlords to pay the security deposit interest. And that was as a result of the litigation. That's correct? Okay.
Correct.
And what is the current, if there is a penalty for the landlord, if the landlord in West Hollywood, for the landlord who doesn't pay the security deposit interest rate on an annual basis? Although we had only 0% since 2013, but is there a penalty or any punitive action can be brought against the landlord who doesn't pay?
That might be a question for John. John, do you know?
Oh, John is still here.
Yeah, there's no penalty per se at the moment, so that's not integrated into the regulations. It would just be something due and owing the tenant. There might be an action that the tenant could take, but there's no penalty that's established in our code.
Okay, so let me ask the commissioners. They probably have questions. I just wanted to ask these two. Let's begin. I'll go this way. Let's begin with Commissioner Martz.
Sorry, I have a lot to say tonight. So one of my thoughts of which recommendation to go with is a lot of landlords are not savvy people. As a landlord tenant law, I've dealt with many who are terrible, many are good, but I don't want to add complex mathematical computations onto their tasks. So when you were compiling this wonderful presentation for us, which of the different options did you find to be the easiest, or were they all kind of similar if you were in the landlord's shoes?
They all have their different pros and cons. But the second one would include both online savings accounts. And I think I may not have written this clearly enough, but to include online savings accounts, meaning that the average would include both the brick and mortar locations and the online savings accounts.
Okay.
But a combination of the two might be favorable. They each have their pros and cons.
Got it. Okay. And let me ask another question. Would the city be calculating this on an annual basis and then publishing it, or would it be on the landlord to do that when a tenant moves out?
So the city would be publishing it. We send out our newsletter in the winter, and we include that that calculation on there.
Okay, perfect. Then my opinion is, if the landlord is going to be holding a tenant's money, which it's their money until it's used on security needed purposes, if at all, if the tenant was holding on to it, they could invest it. I don't like option one where there's not any rate paid. I'm indifferent to the other two, but I do like having it at the rounding to the nearest tenth, because right now with interest rates so low, it can go to zero. So if we have it at the 10th, at least something's getting paid out. And for a long time, especially with rent stabilized places, some of our tenants, like the one we just saw in our appeal, have lived there for many, many years. So they may not have this money back to them for a decade, 2 decades, or longer. So I do think it's fair that we have landlords pay something. So again, I'm indifferent between 2 and 3. I think 2, adding in the online, is probably good, because sometimes they pay a little bit better than the brick and mortars. So 2 and 3 are my choices, but I like 2 the best. Those are my comments. Thank you.
Thank you. Vice Chair?
Thank you. First, I want to thank staff for this report. This was something I've been thinking about for a long time, and I'm glad to see that it finally came to the commission. And I really appreciate all the research you did, because it gives us quite a few options to work with, and give us an idea of what's going on in each city that we can play around with to see what might work best for West Hollywood. I did want to clarify, and I don't know this to be fact, but the way I read if you could pull the slide back up for Santa Monica, please. This shows the Santa Monica option. Or not the option, but Santa Monica's procedures. Is that possible to pull that back? Thank you. Now, the way I understand the Santa Monica ordinance, and please, if somebody else knows differently, correct me. It's not saying that the tenant doesn't receive interest. It requires that the money be put into an interest-bearing account, and then limits any withdrawals by the tenant or by the landlord, meaning that in the end, after the landlord takes out what they are legally allowed to take out at the end of the tenancy, or for whatever damages, whatever would be remaining at whatever interest rate has been there over the years would go to the tenant. That's my understanding. I don't know if that fact is that's fact, but that's my understanding of how the ordinance would work. So let me first, maybe Yasmin, do you want to comment on that? Do you know? I mean, I'm not saying it's fact, that's the way I interpret it, and I'm wondering if you have any thoughts on that.
That's my understanding as well, since they do mention that they're required to be placed in interest-bearing accounts, that would be the natural result of that requirement. So we have the same understanding of it.
Thank you. So I would, and I also want to thank the staff for including the 10th of the percentile, I don't know how West Hollywood ever went down the path of the 25th percentile, but I think we see in the past years, the past 12 years, I think you had listed how it ended up being 0 because of the 25th percent or the quarter percentile. I definitely want to go, if I could choose which way to go forward, I would definitely want to include the 10th percent, nearest 10th percent. And then also I had a question about how did you determine the banks on, or maybe not even how you determined tonight, but how would the city moving forward determine which banks online to make part of the calculation? Because when I looked up this earlier tonight, when I looked up the best high yield online savings accounts for June 2021, it brought up a bunch of banks that I had never heard of, but they were all federally insured. So they're legitimate banks. Obviously, some of them have minimum requirements that we wouldn't want to go that route, but a lot of them range from 0.57 to 0.50, about 10 of them. So I'm just curious, how did we determine those banks for the example, and then how would we as a commission recommend moving forward if we wanted to include online banks? Is there any criteria that's been thought of?
So I somewhat connected to what you just said. When I was doing this research, I did want to go with banks that I was familiar with for the most part, sort of the bigger banks that we're all aware of. But I do welcome any suggestions moving forward for how we would limit. I know currently we don't have any requirements as far as the brick and mortar locations or outside of the geographic, like brick and mortar locations for the banks that we use for the current interest rate formula. But yes, I welcome any suggestions for how we would limit or identify banks moving forward.
Sorry, Yasmin, missed that part. You said there's no requirement for the bank location?
Oh, that currently we don't state which banks we use. We just say 5 banks with locations in West Hollywood. So moving forward, if you were to amend it, I would welcome any suggestions for how we would identify the banks.
So there is no current municipal code that requires to have those 5 banks located in West Hollywood. Is that correct? Or it has to be located in West Hollywood?
It has to be, currently
Has
it
to
does.
be located, okay. Yeah, thank you.
In your research, did you discover any like inherent problems in if we were to go with a route of, say, the average of top, whether it be 5 or 10 top FDIC insured, obviously, online banks with, say, no minimum balances? I mean, do you in your research, did you find any, or does anything come to mind that would cause a problem with that approach?
My only thought would be that a landlord who is used to using the physical banks would be hesitant to bank somewhere that they're not familiar with or with a name they've never heard of. Like the trust might not be there for these newer banks that are more well established or not as well established as our traditional banks that most of us are aware of. But I mean, they're FDIC insured, and so they're regulated, they're legitimate banks, but the trust might not be there in the community. Is my only thought.
No, that makes sense. Thank you. Then I would be interested to hear what others think about how we set the criteria of those banks, but I definitely would want to encourage us to go a route and also consider a route where we do something like Santa Monica, but with so we would require that the landlord place the money in a interest-bearing account, and the city will still have an established rate, and whatever the higher of the two comes out to be is what the tenant receives. So if the interest-bearing account gives them $2 at the end of the year, that's what they get. Or interest rate gets $2 a year, but the city comes up with an average of 0.6 that gives them $1.60. They would get the $2 because that's what the real amount was that they had earned. The flip side of that would be also that if the landlord didn't have it in a higher interest, the landlord would be making up the difference between what they had actually earned on interest that year and what the city had established as the average for the year, which I'm sure any way we do this may happen anyway to some landlords who aren't paying that close attention. So those are my recommendations. The combination of Santa Monica and the direction we're going of choosing the top, however we choose the criteria, but definitely the allowing for online banks to be calculated into the calculation. The 10th percentile, I think that covers it. Thank you.
Thank you, Vice Chair. Other commissioners, Commissioner Ayers, any thoughts?
Just, I am leaning toward the recommendation number 2. I do believe that 1 is not even being considered by myself. And I'm also, I also like what Berkeley has, which is to issue payments, landlords issuing payments to tenants each December, either as a cash payment or a rent rebate. I like the idea of giving landlords that flexibility of how to issue the payment, as long as they do. That's all I have.
Thank you. Commissioner Montemayor.
I actually had very similar comments to Commissioner Ayers. I'm not in favor of recommendation 1. I'm indifferent towards option 2 and 3. I suppose I do lean towards 2. That's just a personal preference. And I too actually took note of the Berkeley model and would be interested to see if there's support from the commission to do an annual payment similar to the city of Berkeley. Those are the summary of my remarks.
Thank you. I think I missed Commissioner Copeland.
I do agree that something needs to be paid. We've been at 0 for a long time, a number of years now. And I like what Vice Chair Kirby said about using the nearest 10th percentile rather than what we're doing now, because we keep ending up back at 0 with interest rates as low as they are. I'm leaning toward option number 2, but I would like to include online banks. I'm also open to annual payment or deduction from a rent if that's the way the commission wants to go as far as the interest payments themselves.
Thank you. Commissioner Maggio?
Well, it's a difficult one for me because these interest rates, are really nothing. They're absolutely nothing. Can you imagine you give $3,000 for a security deposit and you get what, 0.40? If you put $3,000 in AT&T, you would get 7%. I look at it that way. But the only thing I really like is the rebate idea. I think that has a lot of logic attached to it. I also would like to find a way for people to really get their security deposits back, because I think you see more people losing their security deposits and not having the energy or maybe the money to fight to get that money back. I think maybe that's where our fight should be. How do we get the security deposit back into the hands of the tenant? Not these measly little amounts that really don't add to anything. So I don't know. I like rebates, but I'm not sure I like any of these 1, 2, 3. Maybe we should eliminate it until there are real interest rates that mean something. Thank you.
Thank you, Commissioner. First, I want to clarify. So when we had about 0%, of course, at that time, the payments were also based on the annual payments, correct? In West Hollywood. It's not something new that like Berkeley does every December. In West Hollywood, the owners would also issue the payment of the interest rate once a year, right? Is it correct? Yeah. So it's not something new. I don't know if it was in December. Do you guys remember, Jonathan? Maybe you remember, since you've been working for the city for longer than Yasmin. But was it in December or was some other month? I just wonder, because it's been so many years we haven't,
When the payment must be made?
Yeah.
Well, the regulation as it stands, no later than the January 31st of the following year, which means basically a month after the accrual, is completely manifested.
Okay, so and as we know that our commission would have announced the percentage, and then the city would have sent the letters out and the form, and I think they would create the form, something like that, and then the owners would have issued them, whether it was a notice or something, and send the check to the tenants. So it was also done on an annual basis, once a year. So that's not something really unique what Berkeley does it, but Berkeley does it in December. Well, okay, my choices. So I think whatever we do, we can do a combination, and and as I see it, my fellow commissioners, you all in favor of doing some sort of a combination of things here. And thank you, Vice Chair, for clarifying about the Santa Monica, and also Yasmin. That's the Santa Monica. It's not that they're not paying on an annual basis, but there is a account where they deposit put the security deposit, and whenever the tenancy ends, at that time they will clarify how much the tenant will get back. So I don't like that model, to be honest with you, although the tenant seems like he's not losing the money, but I'm not in favor of it. And I'm pretty sure if it was not for whatever the litigation was, the Santa Monica would have probably used a different method. So, but speaking about West Hollywood, so I am kind of leaning towards option number 2, and I think it was Commissioner Ayers. Thank you for bringing this up. Maybe incorporating what Berkeley does in terms of the rebate could be, I don't know. That's what I'm currently leaning towards. But I'm not saying that this is like what I want to see, but definitely I want to see the rounding up to the nearest 10th of 1%, and 5 banks are fine. Obviously I cannot, pick and choose which banks. These banks that are currently used, I think I'm fine with them. They're reliable banks, and that is important. And also online saving accounts. I don't know how that, although it's in report and I read and I heard, I don't know if that would create additional complication or not. But I like the idea also to include that. So at this point, I'm kind of in favor of option number 2, but maybe, commissioners, if you want to add something, make some additional comments. And I see Vice Chair wants to make additional comment, and also after that, Commissioner Marks.
Is that a question? Well, a comment about. So I think that there's consensus around 2, which is the concept of allowing for the average of online savings accounts, which will give tenants a higher, well, historically, it would give tenants a higher interest rate for their deposits. The question I have, though, is, to be fair, there should be some sort of criteria. Like currently, there's a criteria that has to be 5 banks in West Hollywood, brick and mortar, the average. You know, someone, a landlord can do that math on their own and figure out kind of what they're looking at. If we just say 5 FDIC insured online savings accounts, rounded to the nearest 10th of 1%. So if we don't limit it in some way or create some sort of criteria, I think it makes it more difficult for landlords. Granted, we're only speaking about, you know, a few dollars at the most. But I just feel like it's unfair just to that means every year, whether it's Yasmin or whoever that does their online search, like they're the ones deciding right there in that moment which of the 5 banks from online they're looking at. So that's why I was questioning earlier about the top 10 or the top 5. But when I did that, I pulled up a bunch of banks that I hadn't recognized, and I agree with Yasmin about the, you know, the trust of landlords, and especially many of them. Well, yeah. So I just want to have everyone think about that too. Like we can't just say 2 and then be done with this. We need to dig a little bit deeper, I think.
Thank you, Vice Chair. So we'll go around with another round of comments, and we'll vote or something. Commissioner Moritz.
Yes, could staff clarify the difference between what Berkeley does with their rebate and whatnot versus what West Hollywood currently does with the security deposits on January 31st?
Yes, let me just bring the presentation back up.
Thank you.
It is now hiding from me.
Take your time.
I may have closed it. Let's see. There we go. Sorry about that. Can everybody see that?
Yes.
Yeah.
So the Berkeley RSO uses the Berkeley bank rate, which is the rate equal to, so they actually specify their own rate.
Calculation, sure. I'm more interested in the rebate portion. I think it's that first sentence or 2. And how that differs from West Hollywood, if at all.
Yeah. That's a good question. Jonathan, do you know if there's a requirement for how the landlord procures that interest rate payment?
It doesn't seem to be fundamentally different.
Okay.
Right. That's my understanding is, and for because I don't think we have West Hollywood's written on there, but I'll read it just so, because I think we're focused on Berkeley, but I think Berkeley basically does what West Hollywood does. So the city of West Hollywood requires that tenants be paid interest on their security deposits by January 31st of each year in an amount determined by the city, et cetera, et cetera. Tenants who do not receive the interest on their security deposit by the 31st of January may deduct the amount owed from their rent on February 1st. Tenants can also deduct for past years that they haven't been paid up to 3 years. So from my point of view, we already have a mechanism in place for a safety valve for tenants that have bad landlords or absent landlords. So I don't personally see a need to address that portion of it. I think part of the reason we may not be aware of this, especially newer commissioners like myself, is that it's been at 0 for I don't know how long, but that means that there's nothing to pay out. So the city hasn't had to deal with that. So I think Berkeley does it great, but I think we also do basically the same type of remedy here on getting your interest back every year. So I would say I'm in favor again of option 2, since we have that remedy already. And that's all. Thanks.
Thank you. Additional comments from other commissioners? Commissioners, anything else? Commissioner Copeland, Commissioner Montemare, Commissioner Maggio?
Just to lend my support for number 2.
Number 2, okay. Yeah, and I'm thank you, Commissioner Mars, for finding that part and reading it for us. Yes, as I also remembered, so that's it's not a lot different because the city was totally required payment of on an annual basis, and I'm glad to hear that that was in the ordinance that the tenant may deduct from the rent if the check was not paid, not received, the payment on the interest. And in addition, the tenant could deduct for the past 3 years, right? That's what it says, Commissioner Marth. Okay, so it seems like it's beautifully written even that time. So therefore, the Berkeley's model is not that is not something that would change anything. So I would say our model is better. Because the tenant has a flexibility, and the landlord has a flexibility also. If the landlord doesn't want to issue that 20-cent, I don't know, rebate or a reimbursement, so the owner can, you know, with the understanding of the landlord, the tenant can deduct it from the rent, or not even with the understanding, because it's already in the ordinance. So the owner cannot say you're deducting without my approval or anything like that. So I agree that we need 5 banks, and I agree that we need to run to the nearest 1/10 of 1%. So I'm in favor of number 2. Oh, right, that includes also online savings accounts. And thank you, Vice Chair, for clarifying that online savings accounts a benefit of it. So I would say number 2, but keep what we have currently in West Hollywood in terms of the payment on the annual basis or deduction from rent. And also, I believe we should keep that 3-year the option for the tenant to deduct for the last 3 years if the owner hasn't been reimbursed on the annual basis. And I see Vice Chair want to speak. I just want to ask the question. After, when the commission announces this interest rate and it is published and everybody is aware, so the actual enforcement, collection, or anything, the department doesn't deal with it. Is it correct? So the department wouldn't accept an application to review or to set a hearing. That would be a civil matter for the tenant to pursue civilly, maybe through consumer affairs or some other channels. Is that correct?
I'm sorry, did Vice Chair Kirby's want to comment?
And you can correct me if I'm wrong, but no, the response is that the tenant deducts it from their rent.
What if the tenant? I thank you, Vice Chair. I'm sorry, I didn't know you wanted to speak about that. So what if?
No, I have a separate question. That's what
you're still gonna talk. Speak about whatever you want to speak. So, but what I'm saying is, what if the tenant? Sometimes they're afraid to deduct from their rents. The landlord doesn't give anything. The landlord doesn't issue a written notification. Hey, go ahead and deduct this 20 cents from your rent, and the tenant does it. So I don't know why I have this 20 cents in my head, but whatever the amount is, if the tenant is afraid to deduct and goes to the city, what information the city would provide, if any?
Yeah, this hasn't come up before, actually, especially, I think, my tenure, because there's been no interest rate. It's been 0. So in terms of Yeah, in terms of whether or not this would be collectible as an overcharge or as an improperly charged fee, we'd have to do some digging to see if we've
Okay.
accepted those cases before. I know obviously if the commission, as it looks like it's doing, is directing staff to move towards something that would establish an actual interest rate going forward, then we're going to have to do a little research to see whether or not there's a remedy through the administrative process. I just plead ignorance because it's just hasn't come up.
Hasn't come up. Yeah, well, fair enough. So, all right. So with that, I know that the Vice Chair wants to make some additional comments, and after that, we'll just probably going to wrap up our discussion on this.
So let me address the first thing first, but then I will go to what my real comment is. So
okay.
The remedy is, Mr. Holler just said, the remedy is the tenant writes a reduced rent. I mean, they take it off their rent. So what normally happens, and I don't remember what year this was, and but we get a form on the years that there is an interest rate. We get a form in the mail, just as we get our annual increase form when it says here's the 4% calculation. We also get a form, because I've gotten it as a tenant here in West Hollywood. We get one form that says the city decided the interest rate was this much, and then it tells you how to figure out what your security deposit is. You have to fill in your security deposit amount, and your landlord actually, I think the landlord has to fill it out and give it to you. But it gives you the amount right on that form. So I don't know what more the city can do to make this an opportunity for the tenant. But tonight's discussion about the change of the interest rate calculation, I feel like I wasn't heard. Maybe I wasn't clear enough. So if we choose number 2, which is great, I'm all supportive of number 2. What 5 banks, what 5 FDIC insured online savings accounts do we use? That's what I would suggest that we come up with a remedy or some criteria for.
Oh, so you're saying that we should, whether we should select create a criteria for selection, or we should select the banks? So what you're recommending?
I would not recommend that we select individual banks. I would recommend we select a criteria that's used from year to year. The only criteria though that I can come up with is the top X, the top 5, the top 10. But that's what I would like to hear from other people about.
So if the IC insured, that's already a criteria, right? Obviously, and the location in West Hollywood, that's another. But again, staff may speak about it. So if staff wants to address those questions by Chair.
Well, Commissioner Martz has his hand up, so.
Oh, Commissioner Martz, I didn't see you. I was looking at Jonathan or Yasmin who was going to speak, but yeah, go ahead, Commissioner Martz.
That's no problem at all. I would, like staff to weigh in. I don't want us to put so many complex rules and requirements on them that they can't do their job. They've been doing this for X number of years, picking these banks already. And I know Commissioner Kirby probably wants to have some guardrails on that, which I think is a fair point. I would say if I'm crafting this down the middle, that it would be 5 FDIC insured banks, 2 of them which are from the top asset class. That way it requires them to follow a formula partially, but also gives some flexibility because the way banks are set up, asset class is very easy to, they publish these every year. FDIC does, biggest banks by assets, but that typically only applies to traditional banks. They don't have a separate one for online. So if we're going this online standard bank hybrid, I want to leave some flexibility for staff to pick the best banks that are online without tying their hands and saying every year they have to pick Wells Fargo, Charles Schwab, whatever the case may be. So I think that's my proposal. That's all.
I think that's a great idea. So anybody else, commissioners?
I agree with that approach as well.
Yeah. Others? Yeah, I would agree with what Commissioner Martz has suggested. But I think those criteria that already exist, in addition to what Commissioner Martz suggested, I think that would be sufficient maybe for, you know, to select those 5 banks. Obviously, you know, we don't want to go into the discussion which banks, and I know Vice Chair is not suggesting that either. But I think those could be the criteria. And if Vice Chair, would you agree with what Commissioner said?
I believe so. I mean, the 5 banks weren't chosen to give staff a 5 option. 5 banks is what were in West Hollywood when the ordinance was created. We only have 8 banks now. But so I'm not trying to limit or expand, you know, staff. I'm just trying to set a criteria. But I think your criteria, could you repeat it one more time? But I think that would probably be fine.
Sure. So we have 5 banks. 2 come from the FDIC's largest banks by assets, and that's updated every year. And I think for clarity, we would say, Commissioner Kirby, you can say your preference here. We can either say 2 of the top 10 or just the top 2. It doesn't really matter to me. And then the other 3 are online banks at staff's choosing, because it's harder to pick online banks because the FDIC doesn't publish those lists. But that gives some guardrails, but some flexibility as well. Go ahead.
I just have a question. Did the FDIC, I don't know that when you say the largest category or the largest assets?
By assets, yes.
Are those banks that we're going to all know, or are those also sometimes those banks that we don't know?
I will tell you. So the top 4 right now are JP Morgan Chase, Bank of America, Wells Fargo, and Citi.
So I would just say we just choose the average of the top 5 of those.
Sure. Yeah. I'm not wedded on anything. I want to respect your kind of desire to have some guardrails while also respecting staff's, you know, autonomy. So whatever you think works.
Yeah, I'm just thinking that as long as, you know, that way we just know each year that, okay, whatever the top 5 banks are, that's the average of, I mean, they have to be accounts obviously with that are no minimum or no high threshold. We're just talking standard savings account, right?
Yes. The problem though is number 2 is standard banks plus online banks. So the list I just gave you are the largest by standard brick and mortar banks. The FDIC doesn't publish a separate list by online banks.
But does it include, does that list include like city, like the 5 online ones that we had here? Capital One, Barclays, American Express, and Discover? Somewhere on those.
No, those aren't in the top 15 of largest banks by asset class. So, and I think the reason we want to include the online is they pay a little bit higher interest rate, but part of the reason they do that is they don't have as many assets, you know, so that's why I'm trying to create this hybrid that works, but doesn't make too much work for staff.
You're suggesting 2 of the 5, or that's where you're coming up with the 2 of the, and then online.
Or we could just say the top 2 to make it easy, plus 3 online banks, or top 3 and 2 online banks.
That does set some parameters, yeah.
So how's that sound for to you, staff and Mr. Manager? Would that be something that the staff can look into?
Absolutely. I mean, if that's the direction, unless there's some, you know, I would, you know, with this, given the fact that there was a challenge to the security deposit scheme of another jurisdiction at one point, obviously I would consult with counsel. And if we saw that there was some kind of issue with what's being suggested, we might come back with something else. But it works for me at this point to come back with what appears to be the consensus, which is, you know, a modification of recommendation number 2. With, I guess the only clarity I would want to have is whether the direction is the top two or the top three. If the consensus is one or the other, that makes it easier for us, and then we can integrate that into a regulation that we can bring back to the council in the not too distant future for their vote. The commission. Forget where I am sometimes.
Correct. Yeah, I think at least we have a plan now, and it sounds really, it sounds reasonable. It sounds good, and I want to thank commissioners, everybody who contributed into this discussion, and thank you, Commissioner Martz, and Vice Chair also, and everybody else, of course. So, staff, there was Yasmin Spideris, thank you for this really comprehensive report. It was very interesting, and it was really also really beneficial to see how other cities conduct this interest rate kind of a situation, because you know, I know for Los Angeles how they do it, but I didn't know about Santa Monica, and I didn't know about Berkeley. So, but it seems like by comparison, West Hollywood has a really a model, I would say, a system of doing this, and it just needs to be updated and refreshed, and that's what we're going to do. Staff, thank you very much for this great report. And Vice Chair is still raising his hand. Vice Chair.
I think we have one clarification from staff is we need to decide if it's the top three or the top two. And then I think we're.
Yeah, I heard that, but
okay.
Before we move on to the specific motion, that we can just decide whether we're going to recommend 3 or 2. Just wanted to make these comments. And Vice Chair?
Sure.
Yeah, I have a question for Commissioner Martz or anyone, but did I just, by doing that, by having the largest asset banks, did we just revert back to choosing low interest banks as part of the equation?
That's the kind of compromise, is if we pick 2, then we know we're picking banks that are established and people know. I mean, we have some of the top, we have a Wells Fargo here, so we're already probably picking them already. But then if we give 3 online banks, then it kind of averages out and brings that up a little bit. So
I'd rather go with a I'll let staff choose which banks. I'd rather go with the pro-tenant higher interest rate banks and let.
I mean, I think we're already picking some, because you said we only have 8, right?
Wells Fargo's on there.
But again, I personally think 2 is great, and let staff pick, you know, from the whole thing, because I think staff understands that tenants need to be protected here. So I trust staff. I like 2 just as written. So if you want to go towards that, I personally am fine with that too. If other commissioners are, it's not my rodeo here.
You're saying as written, right? On the staff report. Okay. I'm going to revert back to that. Sorry for everyone's time for the last 5 minutes.
Okay, so now we're doing 2 top. So yeah, that's one of the.
I'll clear it up. Commissioner Kirby says wants to revert back to 2 as written, which doesn't include top 2, top 3, or anything. Okay. Because it gives staff discretion to pick banks that maybe pay a little bit more. Okay. But again, I'm paraphrasing Commissioner Kirby's and my position, but there's several other commissioners here. So.
Okay, so commissioners, is it clear to you what is suggested, or maybe we're going to, Mr. Manager, so we need to vote on whatever option we're going to pick, right?
Well, you can. I mean, I can operate through consensus as well here. If the consensus of the commission is to recommend option number 2, because there's no formal regulation in front of the commission tonight. So if the consensus of the commission is for staff to come back with a regulation integrating recommendation number 2, the only clarification I need is and I agree with this, actually, this comment by Vice Chair Kerpes, that there still needs to be some parameters established in the proposed regulation that guide staff. Well, I appreciate that all the trust. At the same time, I think that some parameters in the regulation would be advisable so that there's just some guidance each year and staff knows what to look for instead of just picking the appearance of picking random online banks. And we can craft that. You don't have to come up with that tonight.
Okay.
So, I guess unless I hear an objection to number 2 or an objection by 4 or more commissioners to number 2, that's the way we would move forward. And then I promised regulations at the July 22nd meeting. So I'll fulfill the promise by coming back with at least a regulation on this at that meeting based on what's been discussed here tonight. So as long as the commission is in agreement on number 2 with those guardrails as has been stated, then we can return with that, and then you can debate what we've brought back at that time and vote on it.
I think that sounds good. So if other commissioners are okay with that, we have a consensus on number 2, and we'll integrate all those things that were discussed and proposed by Commissioner Martz and Vice Chair Kerpes and other commissioners also. And staff will bring this back on, say, July 22nd?
Yes.
Yeah, on July 22nd for our commission to review. And at the time, we may discuss a little bit further. And by the time, we may do some additional research or may ask questions. And then maybe we'll have a little bit more concrete, more specific discussion on the proposed option. That will be number 2, but it will be changed, obviously. So if that is fine, we don't have to vote tonight, and maybe we'll take a vote on 22nd when we have sort of the final, hopefully the final proposed version. So with that, I would just conclude this topic, and maybe if there is nothing else to add. And just want to thank again Yasmin for the great presentation, and also Mr. Manager and staff who worked on this. Thank you so much, and it was nice seeing you. We are okay. So that concludes our new business item for tonight's agenda, and the next is public comments. I want to ask our secretary if we have any speakers at this late hour.
None at this time.
All right, great. So commission comments next. Commissioners, do you have any additional thoughts, comments on other topics, issues that you want to bring up? Vice Chair?
I just wanted to thank staff again for the report tonight. Oh, can you hear me? Sorry.
Yeah.
Okay. I wanted to thank staff yeah, this is a great idea. Let them do the hard work of figuring out what the criteria is and bring it back to us, because I'm out of ideas. And then I also wanted to just more having to do with my day job. As many of you know, that I work for Assemblymember Bloom in during the day, and we are still assisting people with EDD. It's been nonstop since March. It's taken a toll on many of our staff in our office, but we are still moving along, helping people every day. But I do want to let everyone know, and if the public is watching, that if you do need help with EDD, contact us. But through our website, there is about, and I'm embarrassed to say this, but there is about a 6-week wait time before we can even review your case to assist you. And it will still be some time after before EDD can assist you. We're trying to move that along as fast as possible, but we've got about 1,300 people that have contacted our office as of right now that we just haven't even had an opportunity yet to look at their case. So we're trying, we're going to get to you, hang in there. But in the meantime, keep trying to call EDD yourself, morning, evening, afternoon, anytime you can, go on social media, figure out what others are doing to try to get into EDD. And you can see some hint or some suggestions on our website, on Assemblymember Bloom's website, to try to get into EDD via phones, but it's difficult, and we're going to help you, but it's going to be a little while. So just wanted to say that.
Thank you. Vice Chair, other commissioners? Any comments, Commissioner Copeland?
I just wanted to thank staff for all the work that went into this report on amending the security deposit interest formula. And it was very thorough and very clear. And I really appreciate all the work that went into it and that's going into it in the future after this discussion tonight. But just want to say thank you.
Thank you,
Appreciate it.
Commissioner. Commissioners, other commissioners? Okay, no other comments. Staff
I have
comments.
one.
Oh, Commissioner Martz.
Sorry. I just want to, I know that there's talks about returning to city council in-person meetings. Potentially we would follow after that. And so I just want to thank staff above and beyond the thanks we already gave them tonight for the hard work that's going to go into that and take a while to get used to that. So I appreciate all that you've done. And then also a congratulations to our new city manager, David Wilson, who was promoted and has worked for the city for a long time. So I hope and believe that the engines of the city will keep running as they've been running for many years. And hopefully we don't see any hiccups along the way, but I don't expect to. But exciting new times as we transition to different leadership in the city. And that is all.
Thank you, Commissioner. All right, other commissioners? All right, I see no other comments. The staff comments is next. Anything in addition?
I'd just like to thank Yasmin for her work tonight. She definitely did all the heavy lifting on that item, and appreciate the commission's direction in helping us bring something back to you on July 22nd. Thanks and have a good evening.
Thank you, Mr. Manager. All right, at this time I will adjourn this meeting until the next meeting of the Rent Stabilization Commission. That will be held at 7 p.m. on Thursday, June 24th, 2021 via teleconference. Thank you and good night, everyone.
Good night.
Bye, everyone.
Good night.
Good night.
Bye-bye.
Good night, everyone.
Bye.